Mr. Valdez, you've been charged with the offense of prostitution. It's my understanding that you have worked out an agreement with the state, a plea bargain. Before
Yes,
we
sir.
proceed, I need to explain several things to you. First of all, you have constitutional rights and protections. One is the right to remain silent. That means you do not have to make any kind of statement. You don't have to answer questions. You don't have to submit paperwork with your signature, especially papers that admit or confess to wrongdoing. You have the right to a jury trial. That means you and your attorney with the state would select 6 citizens from a panel of impartial citizens who would hear the entire trial, all the evidence, whoever would testify, and decide whether you are not guilty or whether you have been proven guilty beyond reasonable doubt. You have the right to confront witnesses. If you decide to go to trial, the state would have to try and prove your guilt by submitting witnesses, evidence, if any. You and your attorney would have the right to question, cross-examine, or challenge any witness who would testify. That's called the right of confrontation. You have the right to appeal. That's a right that's difficult to do, but it is a right that wherein you or your attorney or the two of you together could demand that a higher court review the official record in this proceeding for whatever legal challenge you wanted to make. That right you have to be careful with because it has time limitations. It also requires certain documents and information in those documents. So it's not an easy thing to do, but it is a right that exists nonetheless. And also you have the right to demand that you have a full open hearing in open court. I realize you're in an open courtroom, but that is not the same thing. In order to proceed, you have to consent to do this by video conference, which is how we're doing it. I'm on a computer, so are you. We don't have the state or anybody else with us all together in a courtroom. But you have that right to demand, and in fact, so does the state. Both sides have the right to make that demand. Those rights that I've explained to you, did you understand what they are?
Yes, sir.
Right now, you've already admitted, or I ask you, did you review a document wherein you gave consent to do this hearing by video conference?
Yes, sir.
All the documents that are part of this record that are in this proceeding that have your signature, did you review them with the help and the guidance of your attorney, Mr. Hicks?
Yes, sir.
All right. Now, one document is the document that's called Defendant's Waiver of Constitutional Rights and Court's Admonitions. That particular document reviews the rights and protections that I did, that I reviewed with you verbally, and that document has it in writing. It reminds you and you acknowledge that you're aware of all those rights. It also acknowledges that you are aware that whatever deal you've made with the state, it's not binding on me as a judge. As a judge, I have the authority to say yes or no. In fact, I have the requirement to say yes or no regarding your plea bargain. If I reject it, or if I give you a punishment properly within the correct range of the offense to which you plead, but the punishment is greater than what you've agreed to, in either of those two cases, the law would allow you to start all over again, and nothing that you said or anything that you signed would be used against you. Is that understood, Mr. Valdez?
Yes, sir.
All right.
Yes, sir.
Another document that you've signed is titled Trial Court Certification of Defendant's Right of Appeal. I went through the process of explaining to you a while ago what the right of appeal essentially is. And in doing so, I now inform you that in that document, Trial Court Certification, Defendant's Right of Appeal, you're informed that if you persist in participating in this plea agreement, then you do not have a right of appeal. Are you aware of that?
Yes, sir.
You also have signed a document that's titled plea agreement. Did you review that with your attorney?
Yes, sir.
Did you understand it?
Yes, sir.
All right. Also, you have applied for probation. State, what will be the type of probation here?
Judge, it's deferred.
All right. Did you sign a document requesting that I grant you deferred adjudication? Deferred adjudication is a special kind of community supervision wherein you will enter a plea that's sufficient for me to convict you, but I will not find you guilty. As long as you live up to 100%, every bit of the conditions of supervision, then the case will be dismissed and you are not convicted of the charge to which you enter a plea. If you violate the conditions, either by failing to do them or refusing to do them, then the state may ask me to bring you in for a hearing after official notice, have a hearing at which the evidence will be submitted, and if I believe it is sufficient, I will then enter a finding of guilt and convict you, and that conviction will follow you the rest of your life. If that happens, then you'd be looking at a full range of punishment. State, is this a B, Class B?
Yes, Judge.
That means you'd be looking at a fine from $0 to $2,000 and jail from 0 days to 180 days.
That's up.
Is that clear?
Yes, sir.
All right. Now, are you a U.S. citizen?
Yes, sir.
And how do you make a living?
Right now, I'm not working at this time.
When's the last time you worked?
I last worked a couple months back as a tattoo artist.
All right. Are you going to go back to that after this is over?
Yes, sir.
How much do you normally make in a month on your profession?
I'm not sure.
Okay. Well, I'll guess $10,000 a month. All right. You're making a lot of money.
They're gonna make you pay for me. Give him a figure
I'm
per
sorry.
person or something.
What do you
Like
believe
$2,000 a
in good
month.
faith is the amount that you can make?
What I could make is $2,000 a month.
And as low as how much a month? Or as low as how much a month?
As low as 1,000 a month.
Do you have children you support?
Yes, sir.
How many?
2,
What ages?
8 and 4.
And does your wife works outside of the house?
No, sir. I'm not sure.
You're what? You're what?
No, sir.
All right. State, tell me the agreement. What is going to be the plea and the punishment?
Judge, the agreement is, the paperwork says no contest for the plea. And it is 12 months deferred, a $200 fine plus court costs, 24 hours of community service, the AIDS awareness course, and this is to run concurrent with case number 631028 out of County Court 13.
You don't bite. Judge,
Yes.
he has had one vaccine. Will that substitute for some of these 24 hours of community service in your court? Some courts will allow a discounted number of community service hours if the person has been vaccinated against the pandemic.
I don't
He
do,
had,
I don't do that, Junior. Especially where he's getting a hellacious break like this, deferred adjudication, $200 fine, that's about as low as you normally would go, or at least that I'm willing to. Anything else, Juniors?
yes.
Mr. Hicks? Hello?
He's calling you.
Asking if there's anything else.
No, nothing more, Your Honor.
Thank you. All right, Mr. Valdez, officially to the charge of prostitution, how do you plead, sir?
What I plead is no content.
All right, a no contest plea is considered a guilty plea in this court and is sufficient for me to convict you based alone on your plea. You understand that?
Yes, sir.
I find that your plea is sufficient to convict you, but I do not. Instead, I approve the agreement that's been made. You are granted 12 months deferred adjudication, a $200 fine plus court costs. You'll perform 24 hours community service restitution. You will complete an AIDS awareness program. You will have the supervision in this case will run concurrent with the supervision in case number 631028 in county court at law number 13. Mr. Valdez, take care of yourself and your family. I wish you a good Thanksgiving.
Your Honor, supervisory fee?
Supervisory fee will be the minimum of $25 a month. All right. Thank you, folks.
Your Honor, I
Thank
can
you,
speak to him, please.
You need to, Mr. Valdez, don't leave this hearing until you have met with Ms. Maricela Luna. She's on the screen here under M. Luna, CLO. She will explain to you how you're going to get into the probation supervision in this particular case.
I'll put him in a breakout room, Judge.
You'll also have to be coming in within 1 week to put your thumbprint on documents. All right. Are we ready on Contreras or not?
You need to go on Adobe, Judge, to sign the paperwork.
Another again?
Is that correct, Mr. Mauer? You and your client signed off on it?
They're both signed, yes.
Well, I don't see anything here. I'll try it again. Waiting for Joel. And nada.
I should have sealed in court paper days, Judge.
Mr. Contreras, did you press send after you signed?
Yes, ma'am, I did.
Check with Russell. They might already be back because I signed those a while ago.
Well, if they say they're ready, Judge, signed, so if you want to proceed, you can.
Very good. What's the charge on 562343?
GDBI, Judge, MTR. The intent is to, I think, terminate UNSAT with the court's permission.
And 629936.
Driving while licensed invalid, Judge, and the intent by agreement is to do a judgment satisfied.
Boy, you really know how to work me hard, huh?
I've tried to streamline things, but this computer stuff I hate.
I hear you. Okay, I'm gonna try one last time to see if it's come into the. I think it's probably done, Patty, because I've double checked and triple checked and it's not here.
All right, Judge.
Alrighty. Court calls cases number 562-343 and 629-936, State of Texas versus Jeffrey Contreras. 562-343 specifically is a motion to revoke probation on the charge of DWI. 629-936 is a charge of driving while license invalid. Mr. Contreras, please raise your right hand. You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you. You may put your hand down. Mr. Contreras, before we proceed, there's a little distinction in these two matters. One is a motion to revoke probation on a prior proceeding that's already been had and to which you entered a plea. The second one, DWLI, is a new case. It is a charge. In either case, you have the right to remain silent. The right to remain silent essentially tells you that you do not have to make any kind of statement. You don't have to answer questions. You don't have to submit written paperwork of any kind, especially papers that admit or confess to wrongdoing or violation of rules. You understand you have the right to remain silent.
Yes, sir, I do.
You have the right to a jury trial on the DWLI. That right is exercised by you and your attorney and the state selecting 6 people from a panel of U.S. citizens, disinterested U.S. citizens, who would listen to all the evidence, look at the witnesses and whatever materials are submitted. And that jury would decide whether you are not guilty or whether you have been proven guilty beyond reasonable doubt. You have the right to confront witnesses on both cases. The right to confront witnesses means that if any witness testifies in the case, you and your attorney would have the right to question, cross-examine, or challenge that witness. That's called the right of confrontation. You have, in the DWLI, you have a right of appeal, meaning that you and your attorney or yourselves, each of you respectively, could demand a higher court review the official record in this matter and the evidence and decide whatever legal challenges you wanted to make. In the MTR, that is the motion to revoke your probation on the DWI, you have a limited right of appeal. When you first entered your plea on this matter, you were told that you had no right of appeal because you had made a plea bargain. In this particular instance on 562-343, you would have a limited right of appeal, meaning that you can appeal this particular hearing only, but not the original plea that you made. That's the right of appeal. You also have a right in the DWLI to demand an open public hearing, that is an open public courtroom hearing on this matter. And on the MTR, you do not have a right of to have a, well, you also have a right to demand an open public hearing. In both of these cases, because of the COVID pandemic, the only way we can proceed is for you to consent to video conferencing, which is how we're conducting this matter. Do you understand you have those rights that I've discussed with you or pointed out to you?
Yes, sir, I do understand.
On each case, on the MTR and on the DWLI. Is that understood?
Yes, sir, I do understand.
Okay. Now, state what is going to be the agreement on the MTR?
Your Honor, the recommendation is to terminate him unsatisfied.
I'm sorry, I can't hear you.
the recommendation is to terminate him unsat.
That's our understanding, Your Honor.
Is he going to enter a plea at all? We just terminate him unsat and that's it?
My understanding was just term unsat, Judge, without entering a plea.
All right, then, in accordance with the agreement that's been reached between the state and defense, on case number 562343, the court terminates your probation unsatisfactory. On case number 629936, that being the driving while license invalid, state, what is the agreement there?
Your Honor, the agreement is for 1 day Bear County Jail, $0 fine plus court costs, time and money to run concurrent, credit for time served, and we would request that this satisfy the judgment.
That is our understanding. We would ask the court follow it. We also would ask the court to J-set the agreement or the plea.
How's it going?
And what is going to be the plea in this matter?
Guilty, Your Honor.
Catching up on stuff.
Mr. Contreras, to the charge of driving while license invalid under case number 629936. How do you officially plead, sir?
Guilty, sir.
Did anyone threaten you, intimidate you, or promise you anything in exchange for your plea of guilty other than the plea bargain to which you are entering this plea?
No, sir, they didn't.
All right. I accept your plea of guilty. I find you guilty. I accept the agreement and recommendation, that is your sentence to 1 day Bear County Jail. You're granted 0 fines and court costs. You're granted credit for time served, time and money run concurrent. The court finds that you have satisfied this judgment and you owe nothing further to the state of Texas or to this court on case number 629936. Anything else, Mr. Marr?
Yes, Your Honor. Mr. Contreras, I think, has had on either the interlock or one of the breath devices for a sum total of 3 years while he's been on probation. And while we were waiting for a hearing, I would ask the court allow him to have that removed since his probation is now over.
And what is that? The what?
What device do you have, Jeffrey?
The Smart Start device? I just know it by Smart Start device, the one that's in your truck where you actually blow into it.
The ignition interlock then, Judge.
The ignition interlock, yes, sir.
Order, remove ignition interlock monitor. All right, the court so orders. Anything else, Mr. Marr?
No, Your Honor.
All right. State, any question or anything?
No, Your Honor.
All right, thank you very much.
Thank you, Judge. Y'all have a good Thanksgiving.
I see a gentleman